And we'll wait to see if we're joining.
Yes.
Can you all hear us, Robin?
Lizette, can you hear me?
I can hear you.
Okay, perfect.
And
Okay,
Lizette,
yeah,
when I do present, I'm gonna have to share my screen and I won't be able to see hands raised, so you'll have to let me know if anybody wants to jump in.
got it. Perfect. Okay, thank you. Okay, we'll go ahead and call this meeting to order at 6:01 p.m. Welcome everyone to the Community Advisory Council meeting for October 4th, 2023. We'll go ahead and start off with the call to order, and we'll just go ahead and do what we've been doing and go around the room. Everyone give your name and state what district you represent. I'm Lorena Barron. I represent District 3.
Nancy Pemberton, District 5.
Tom Rose, District 2. David Jones, District 2. Nathan Solomon, District 1. Donald Bowen, large. John Jones, Sheriff.
And we have some members of the community sitting with us today. We will go ahead and, we also have council member Robin George participating via Zoom, and she notified us on September 28th that she would be attending remotely today pursuant to AB 2449, which allows up to 2 virtual attendances per calendar year for Just Cause. The circumstances of the Just Cause for today's teleconference participation, Robin, can you let us know what the circumstances are?
Yes, I had surgery last Friday and I am not allowed to drive or do anything very much for 2 weeks. So that's why I'm on Zoom with you.
Okay, thank you. And this qualifies as Just Cause and no vote is needed in order to allow Robin to participate. So we'll go ahead and proceed.
Through the chair.
Oh, sorry. Robin, do you have anyone else over the age of 18 present at your remote location with you?
I do. My daughter is here.
Okay, can they describe the general nature? Oh, you just said it's your daughter. Okay, sorry. First time I'm doing this. Thank you. Okay, so we'll move on to the commitment to civil engagement, and I'll turn it over to Nancy.
So all of are encouraged to engage in respectful, non-disruptive communication that supports freedom of speech and values diversity of opinion. We, the members of the CAC, have adopted a list of norms referred to as our Design Team Alliance, which describes the way we want to show up and be in community while modeling collaborative behavior. We request that CAC members, staff, and the public follow the CAC's agreed upon norms, which are: be tough on the topic, not on people; respect all participants in the meeting; respect each other's perspectives, even when you disagree; respect each other's time; stay within the meeting's time and content parameters; practice active listening; listen with an open mind to all information, including dissenting points of view; speak to others as you would like to be spoken to; allow others to speak without comment or intrusive sounds; honor freedom of speech; and call each other in. Thank you.
Thank you. We'll move on to item 3, the approval of the September 6th meeting minutes. Did everyone get an opportunity to look at the minutes? Are there any comments from members of the council? Okay, Robin?
Nope.
Any members of the public have any comments on the minutes? Seeing none, then we'll bring it back, and if you're all okay with the minutes, can I get a motion to approve?
So move.
Okay, thank you, Tom. Second,
Second.
thank you, Casey. All in favor, say aye.
Aye.
Noes, abstentions?
Abstain.
Okay, thank you. Minutes are approved. Moving on to item 4, openings and appointments. We currently have vacancies in District 3, District 4, and District 5. So if you're interested, please consider applying. And you'll be interviewed by the Board of Supervisors, and they will make the decision on appointing you to the CAC. Item 5, correspondence items. Over the past couple weeks, we've received comments from residents from all over the county Most of the comments we were copied in and they were addressed to the Board of Supervisors, and they were regarding the annual report and the importance of IOLERO and transparency when it comes to law enforcement oversight. And all of those comments were shared with members of the CAC. We do not have a director's report tonight. John is in New York, I believe. And he didn't have a report for us to read either, but we will get one next month. Item 7, Sheriff's Liaison Report. Do you have any report, Chris?
I don't really have a report, but one of the island auditors has asked to expand the training in our simulator. So yeah, basically we do the scenario, volunteers available to. So I want to extend that to the CDC, so we're going to see. But I'd rather fire this machine. So you guys want to do that? You're welcome to.
Do you have a time schedule?
No,
Yeah.
once I figure out who wants to participate, then I can also.
I will say I actually participated in that when Lieutenant Cutting was in the department, and it's really valuable. I think you learn a lot and you get put in the various scenarios that law enforcement officials face every day. So you get to kind of see the difficulties in handling situations. It's a really good experience. So I definitely recommend it. Anything else?
No.
Okay, thank you. Moving on to our business items. Item A, receive and discuss the presentation on the Ralph M. Brown Act and Public Records Act. And we'll turn it over to Elizabeth for the presentation.
Good evening. My name is Elizabeth Coleman. I'm one of the deputies in County Council, and I work with IOLERO on all of their general county legal matters. I was requested to make the presentation this evening to explain the basics and provide a forum to answer questions related to 2 different items, one being the Public Records Act and the other being the Brown Act. So we're going to start with the Brown Act. I am going to share my screen in order to share slides with you from a PowerPoint, but once I pull that up, I'm not going to be able to see hands raised. I can hear folks talking in the room, but I'm picking it up through Ms. Camacho's speaker. So if you wouldn't mind speaking loudly and clearly if you have a question, and please feel free to interrupt. The intention here is to have time at the end of both presentations to ask questions, but if something's unclear, feel free to stop me and jump in with a question. So give me just a moment to get the presentation up and share my screen. Can you see it?
Yes.
Great. Okay. So the Brown Act, I know that everyone is generally familiar. I know that written materials were provided to everyone when folks join the commission. This is to give you as much in depth as we can, and hopefully will be useful to you. So the intent of the Brown Act is transparency and public input. Government officials are elected by the people and govern on behalf of the people. And the intention of the Brown Act is to make sure that the public has access to observe, monitor, and evaluate its government officials. When does the Brown Act apply? All meetings of a legislative body of a local agency are required to be open and public, and all persons shall be permitted to attend any meeting. So the first question is, what is a legislative body? And you as the advisory council are considered one under the Brown Act. So a legislative body includes a commission, committee, board, or other body of a local agency, whether it's permanent or temporary, and whether it makes decisions or is advisory, which is created by charter, ordinance, or resolution, or formal action. So the CAC, having been created under the county code, is itself a Brown Act body. So what about subcommittees? If a legislative body takes action to create a subcommittee, that subcommittee itself becomes its own legislative body. So the requirements of the Brown Act flow down to the subcommittees. The only exception to that would be an ad hoc committee. So if there is, and Brown Act requirements do not apply to ad hoc committees, so long as it is not a majority and it's advisory and not standing. So a standing committee is something that is ongoing and indefinite in term. It has a continuing subject matter, and then it is subject to the Brown Act, even if it's less than a quorum. An ad hoc, by contrast, is temporary, less than a quorum. It has a limited purpose, and it dissolves when it's done. So if the CAC were to set up an ad hoc to talk about a single topic and report back to the full board for discussion, that would, as long as it was less than a quorum, that would usually be considered an ad hoc and not subject to the Brown Act. But if the charter of that particular committee was ongoing, it kept going past the end of the stated purpose, or it was intended to study an ongoing issue, that would be something subject to Brown Act. It's a little bit tricky sometimes to tell the difference because an ad hoc can be, can over time morph into a standing committee. So if the question ever comes up, it's always a good idea to reach out to county council for a quick check on that, and we can tell you whether or not the Brown Act applies. So what is a meeting? It seems like a pretty obvious question, but in the age of technology, it is not always clear what does and doesn't constitute a meeting. A meeting is any congregation of a majority of the members of the legislative body at the same time and location to hear, discuss, deliberate, or take action on any item within their subject matter. So if you break that down to the major concepts, it means you need to have the majority, you're talking about the subject matter, and it's concurrent. So a majority of members shall not use a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action. So what that means is that, even if the committee itself or the council itself is not all talking at the same time, if, for example, representatives of all members or of a majority are talking, that can be enough. So take a look at this picture. Is this a meeting? Well, that depends. So let's assume we were talking about an entity that had a board of 7 members. Well, the first question is, what are they talking about? Okay, well, if they're talking about something that is covered in the subject matter, that's the first aspect. If these 3 people just happen to be on the beach and they're texting with their buddies, not going to be a meeting. If these 3 folks are on the beach talking about business of the board, now it's possible. Well, if it's a 7-member board, 3 people out of 7, that's not a majority, right? So far, looking okay. Even if they're talking about business, probably not a meeting, but we don't know who they're texting with in this picture. So let's say this is 3 members of a board and 1 or 2 of them are texting with other board members who aren't present about the same topic. Now you potentially do have a serial meeting because you've got these folks that are together talking plus the other individuals that they are talking with. When you group them all together, if it's a majority and it's on the subject of the body itself, then you do have a meeting. This is another one that is sometimes not super obvious. Is this a meeting? Well, we're looking at an email here. We can't tell from the 2-line who that is. It says project team. If you scroll down, you can see it looks pretty non-substantive. So on the first blush, this email is probably not a meeting. But let's say that the project team here is the full board. And if this email goes out to everybody, even if it's got nothing in it right now that's problematic, the concern would be what happens from there. So if you send a meeting or send an email out to the whole board and then someone reply all and says, oh, well, did you think about that report we got last week from the director? Wasn't that interesting? You could turn an innocuous email into a meeting by replying all and including all the members in it. So even though you're not physically in the same space, an email is sufficient to create a meeting. So just to go through those examples. Oh, yes.
So on your slide 6, I think you said something about it having to be a legislative body at the same time and location.
Mhm.
does not meet those requirements. So how is it interpreted to be considered a meeting?
So the concept of a series is generally what picks that up. So it does not have to be concurrent in the sense that it has to be at the exact same moment, but it has to be within the same general conversation. Normally folks that are remote from each other aren't going to be having a meeting at the exact same time, but the series, the series aspect picks it up. Also keep in mind that location is a concept that was injected into the Brown Act before all of the current technologies came out. And so as the law has evolved and is adjusting to the concept of technology, the time and location language is still in there, but the concepts that come up in other places in the Brown Act do account for the fact that there are that location can be in cyberspace and the time can still be in a series, but it is a little confusing worded in that way.
Can I follow up with another question? And that is, going back to slide 9, where you're talking about the problem of, actually, it's 8, slide 8, where you're talking about the email. So if all the email was dealing with was setting an agenda and or setting a date and time for a meeting, there wasn't any, I mean, I understand the danger that you're talking about, but an email that just deals with setting an agenda and setting a date is not considered a deliberative meeting. Is that correct?
So setting an agenda could be deliberative. Generally, if that's something that the body would normally discuss, what's going to come back to it, if they're deliberating on the content of what the next meeting will be, that could be. Normally, if you're going to have a full board conversation about the content of an upcoming meeting, you should be having it at the board meeting. Normally, if an email goes out to the entire council asking about scheduling, you should be replying directly back to the person who's coordinating rather than creating the danger. But so that the content of the meeting could potentially be a Brown Act violation if you're talking about substance. A quick confirmation as to, yes, we are going to be there on X date is less of a concern.
Okay.
So and one of the concepts, and I started to talk about this with the serial meeting, an email or a text chain can also be a meeting, even if it's not a reply all that goes out to everyone. So the key concept is whether you're trying to build a consensus, come to a decision through the series of communications. So if board member A emails with board member B to figure out what board member B's opinion is on something, and board member B sends it then to C and says, well, A and I were talking, we think this, what do you think? You can, through the course of the text chain, violate the Brown Act. It may not be, even if it was not itself technically a meeting in that moment, it is an action that needs to be taken at a meeting. And so it's a violation of the Brown Act to come to a conclusion in that sort of a text or email chain.
I have a question on that point.
Yeah.
Say you've got an ad hoc and you're at the limit of the quorum. Someone who's not on that member sends you a copy from this morning's Press Democrat. Can you believe the sheriff in this inane action? If you reply to that email, then we violate the Brown Act. But as long as we're just sending you stuff and you don't reply, we're okay. Is that a fair assessment?
If a member of the board, so you've got 3 people on a subcommittee and then a 4th sends information to the other 3 without comment.
With a comment that, can you believe they do this? But the 3 do not comment back. I would assume there's no problem, but if they send something back.
Well, when you hit at the time that you've got that 4th person engaging in the topic, a single email from one member of the board to all of the rest of the board that is as to the substance is not appropriate. So one member who is not on the ad hoc should not be starting a conversation, an email conversation with 3 members that are on this subcommittee.
And if they do, as long as you don't answer it, is that okay? Or have you got a problem just by them sending something? Did you guys see this?
I'm sorry, I couldn't quite hear the last part of it. What was the
Someone
question?
sent something to the ad hoc committee and said,
Mhm.
have you guys seen this, or you need to
Yeah.
consider this?
Yeah.
And no one replies to that person,
Mhm,
came in by someone who's not on the ad hoc,
mhm.
created any kind of Brown Act problem. And I would say,
Should you not respond? You should certainly, yeah, I would not, I would recommend that you not respond to an email once you've got a quorum of folks involved in a conversation about the content of, as long as the content is within the purview of the board, I would not respond to that. So generally what happens if there's a piece of information that needs to be given to an ad hoc, the most appropriate way to do that is for staff to do that, because then staff, just by sharing information, is not conveying, any particular, I mean, it is possible for staff to act as a conduit in order to build consensus, which is inappropriate. But as a general matter, if there's a piece of information that one board member would like to get to an ad hoc that they are not on, it should go through staff.
Darnell, you had a question?
So to clarify that example, if members of an existing ad hoc are communicating with each other,
Mhm.
the fact that they are an ad hoc exempts them from the Brown.
Correct. So long as they fully meet the standards of an ad hoc, that it is temporary, that it is a single purpose and limited duration, and it's less than a quorum. So an ad hoc of 3 folks, just like they could meet in person without violating the Brown Act, they can also email amongst each other without violating the Brown Act.
So Elizabeth, just to clarify, does it even matter if there's an ad hoc, if there's a less than a quorum of 3 and they're communicating and they're not communicating for the purpose of building a consensus with a majority? That's not a violation either, is it?
That's correct. It is not a violation for 3 members of a 7-member board to communicate amongst themselves, even on the topic of, even if the topic itself is something that would generally be covered by the board. If you are not hitting a quorum and it is not a standing committee, you're okay.
Thanks.
Now, if the 3 people are speaking in email and then the 3rd person reaches out to a 4th and says, hey, Bob and I were discussing this, then you might have a problem. So, that it is fairly strictly construed in that regard. So one demonstration of this is referred to as a hub and spoke type meeting. So if board member A calls member B to discuss something and then reaches out to member C and then reaches out to D, right? It doesn't need to be a straight line serial in order to count as a serial meeting. It can be one person connecting the dots. If the ultimate impact of the communications is that you're gathering, in one place, the opinions of a majority of the board, within one person's understanding, when you're not doing it within the meeting, that counts. So what is not a serial meeting? Individual contacts between commission members and staff, council or others, for example, staff meetings with a commission member to answer questions, are not considered serial meetings. So if a member of ILARO staff wants to reach out individually to folks on the advisory committee and discusses content, even if it's about the matters that the council does talk about, if the discussion isn't to share the opinions of different members of the council, it is okay for staff to meet with different members at different times and to answer questions or provide information. So what is not a meeting? Attendance at a social or ceremonial event where no business is conducted is not considered a meeting, even if there's a majority there. If you run into other folks that are on the council, don't discuss business with them, but it is not itself a meeting to be at a social or ceremonial event. Community forums and meetings of other government bodies are not considered meetings of this body. So if all members of the CAC were to attend the same Board of Supervisors meeting, that would not be a Brown Act meeting. And then attendance at public conferences do not count as a meeting if the board members don't discuss amongst themselves the business of their jurisdiction. Social media. So social media, just like teleconferencing and texting, these are concepts that are evolving over time. The best practice to avoid Brown Act violations on social media is not to discuss anything that is within the subject matter of the council or on blogs or Facebook pages or Instagram or anything else where you could all view and discuss the same piece of information. It is also best policy not to text, email, or engage of other forms of electronic communication during meetings. Particularly if you're in an ad hoc and you're texting with another member of the council, you are potentially creating a quorum situation. You don't necessarily know what other members are doing either. So if you're in the meeting and you're all texting with each other, it could be that there's one public conversation happening about the appropriate conduct of the meeting, and then there is a separate meeting happening amongst a quorum of the members via text or email chain that should have been happening in public but is not. So be aware of that.
Elizabeth, I have a question, and it's going back to a slide or two where you talked about conferences.
Mhm.
So what if, and this is going to happen, a number of people are going to go to a national conference that's about law enforcement review and oversight. So you're saying that if we talk to one another, well, they're not all CAC members, they're IOLERO, staff members, some of them, a lot of them. So we could talk about information that comes up in any workshop that we go to, as long as it's not specific to an issue that is related to IOLERO in particular. Like an investigation or something that we've talked about as a topic of one of our committees or ad hoc, right? So
that's right. So yeah, if you were in a training and one of the breakout groups was about excessive force and 6 of you were in the same room and one of you had a question and said, hey, well, I've been curious about X issue, even though the other members are hearing it and it's within your purview, sort of topically, as long as you're not talking about the actual business of Sonoma County's IOLERO and CAC, that is okay.
Okay, thank you.
Did you combine those two? If, for example, we had 3 CAC members and 3 IOLERO members in Chicago, could they discuss without violating anything?
Yes, because IOLERO,
CAC.
unless IOLERO staff is acting as a go-between in order to get an additional person's input in there, if you're less than a quorum, you're okay. Yeah, staff is not counted as quorum. We are here to serve you, but we do not count for the purposes of the math. Okay. So let's talk a little bit about posting and agendas. Agendas must be posted in general 72 hours in advance. If a special meeting is being called by a board, a 24-hour notice must be given, and as much notice as is possible is best practice. There needs to be a brief description of the items of business, and agendas must be publicly accessible and distributed in advance to those who request copies. Items not on the agenda. There should not be a discussion or decision on items not posted on the agenda. Members of staff can briefly respond to questions posed by the public if something comes up in public comment. Members can ask staff questions, make brief announcements, or make a brief report on their own activities. And members can ask staff to report back to the body at a subsequent meeting or take action to direct staff to place a matter on a future agenda. That is the confines of the manner in which the board should be dealing with non-agenda items. So during public comment, every agenda for a regular meeting must allow members of the public to speak on any item of interest, so long as the item is within the subject area of the body itself. And also the public must be allowed to speak on a specific item of business before or during the legislative body's consideration of it. Public comment. So the public must be allowed to speak on specific items of business before or during the consideration. So this can either happen via a call for public comment at the beginning of an item. It can sometimes be done in the manner, if a vote is being taken, the staff report can happen, and then there can be a call for any public comment before the board discusses the item. Either one of those is fine, as long as the board itself doesn't fully engage in and complete its discussion of the topic before the public has had their chance to weigh in. Public comment when you're dealing with public comment, it is okay for a board to adopt a policy to limit comment on topics, such as a minute per speaker or 3 minutes per speaker, depending on the need. They need to be, those types of restrictions need to be reasonable under the circumstances, based on the time limits or how many folks are interested in talking on a specific comment, or excuse me, on a specific item. Recent changes in the law require that whenever a Brown Act body does limit the time for public comment, it must be twice the allotted time to a member of public who uses a translator to ensure that non-English speaker receives the same opportunity. So if you limit comments to 2 minutes on any particular item, anyone who's commenting through a translator needs to get 4 minutes to give them the opportunity to fully have their comments translated and not get less time to speak than anyone else.
We have a question, Elizabeth.
Regarding the public comment, we have had some issues with members of the public asking either the presenter, the non-CAC member presenter, or a CAC member a question within an agenda item. And we've been told that it might be a violation of the Brown Act to actually answer that question, which for a community advisory council that's supposed to engage in community engagement is quite a frustrating piece of advice to be given. And so I'm wondering why that is, and whether there's a way around it so that we can actually engage in a back and forth with the public about an item that's on the agenda.
If you're within the context of an item that is properly agendized, and the public is commenting, it is generally best practice to let the public make their comments before the board is engaging in its own discussion. So if you get into a significant back and forth with a member of the public at the moment of public comment, you may be jumping the gun on the portion of the meeting where the board is itself supposed to be discussing. So it is not a clear violation of the Brown Act to respond when a member of the public says, well, I want to know why, X topic wasn't covered. If a board member does want to speak on that point, there's not plain language in the Brown Act that prevents that type of a response. But you want to be careful not to get too engaged into a colloquy back and forth with a member of the public such that you're cutting off the opportunity of the public to speak before the full consideration of the board. So best practice would be not to get into an ongoing colloquy with one member of the public during the public comment period.
Thank you.
So I take it the better practice then, Elizabeth, would be to hear the member of the public to go ahead with the remainder of public comment on that item, close it, and then discuss matters among the council, correct?
Yes, that would be my recommendation. And you can specifically respond, and it is in fact good practice to be responding to the issues that are raised by the public in public comment. That is in fact the point of public comment, for you to be able to consider fully the comments that are made, but it is best to let the public complete their comments, take those under advisement until you get to the portion of the meeting where the council itself is discussing, and then get into the issues so that everyone can fully engage in that.
Okay, so I'm sorry, I need to follow up because
Because of me.
if somebody makes if a topic arises and a member of the public asks an informational question, I don't understand X, So you explain that.
Mhm.
To wait until the end means that that none of the members of the public then can comment on the interpretation of that. So
Mhm.
that to me, cuts off community engagement instead of fostering community engagement. And I understand that, not getting in the back and forth and, having a debate about it. But it would seem to me that the chair or the presenter could provide a clarifying response so that the public was better informed in making their own comments. And then the CAC members would be better informed about what the public issues were in making their decisions.
And it is not my opinion that a single response to a question from the public made by a member of the panel in real time would be a clear violation of the Brown Act. It's not best practice in general, but it seems like a fairly low risk proposition. What you're trying to avoid is a situation in which the board is, or the council is discussing the content of the item before the full public has had an opportunity to comment. So, engaging in sort of a dynamic back and forth conversation could be problematic. Providing a single response to a single question in public comment, I would not read as a violation of the Brown Act. And if there are specific discussions we want to have, if there are particular examples and we want to, talk more offline with any, I am counsel to both ILARO and the CAC. So if there are specific issues that have come up that you want to discuss in more detail, particularly in a non-public forum where I can fully and freely advise you as to my legal opinion, I'd be happy to do that.
One, I want to thank you for being here. And two, private is nice, but one of the issues we have is, and using your language, we want to engage in meaningful discussions on how to improve sheriff office's policy or practice to align with the community.
Mhm.
People in the community accuse us of using the Brown Act to try to hide behind so we don't have to talk to them.
Mhm.
This comes up not infrequently.
Mhm.
So to say this is the best practice is undoubtedly a truism. But if it's just best practice and not prohibited, it would seem like Brown Act should lead us the other way. We should have full discussions whenever possible. And I don't know how to draw that line in public. I mean, that comes up in, you have any ideas or any suggestions other than best practices?
Yeah, I mean, I think if there are particular items with which the council wants to engage more fully in a conversation with the members of the public in real time, it might make sense to agendize it as a workshop on that particular topic. So the sort of the default position is that the board itself is discussing, is making a determination or doing the analysis with the benefit of hearing the comments of the public, but not necessarily that the conversation is directly back and forth between the board member and the public at the meeting. So, if there are particular topics that you want to open up a little bit more free form, I think to agendize it in that manner would make the most sense. I cannot point you to a provision of the Brown Act that says a board member may not respond to a public comment, in more that the board cannot respond to a public comment. That it doesn't say that. So it's really just a question of being mindful of what the Brown Act is intended to require, which is to hear the full public before the board comes to its decision. But it does not, there is no black letter law as to how many times one member of the committee can respond to questions from the public. It is okay, and particularly okay for staff to also jump in, if there's clarifying information they can provide.
But there are some clear approaches that are available to members of the CAC, such as the workshop option that you're talking about, where, that is set up for the purpose of hashing things out in detail. And the other one is that non-quorum groups, right?
Mhm.
CAC can engage with a member of the public
Absolutely.
fully and freely outside of the meeting setting. And then, you know, use the more formal approach to the Brown Act meeting when the Brown Act meeting is occurring.
Absolutely.
Yeah.
And I see a raised hand.
Are you ready? Okay. Okay.
I'm sorry, it's hard for me to. Is that a member of,
I'm not sure if you're taking questions from the members of the public yet, are you?
Not yet.
Okay, I'll lower my hand.
Back to you, Alcina. Sorry about that.
so, I'm gonna just kind of roll quickly through the last couple of slides since, we have another entire legal topic to cover. But there are criminal and civil penalties for violation of the Brown Act. The district attorney can file a civil lawsuit for injunctive relief to avoid an action taken in violation of the Brown Act. Attorney's fees are available if someone sues and is successful on that particular point. Each member of the legislative body who attends a meeting of the body where an action is taken in violation of the Brown Act and intends to deprive the public of information to which that member knows or has reason to know the public is entitled is guilty of a misdemeanor. So there's a whole lot of parts to that. You need to be a member of the committee. An action needs to be taken. There has to be an intentional deprivation of the public of information. And they have to have a reason to know the public is entitled to that information. So that standard is pretty high, and particularly with an advisory body, it's exceedingly unlikely to be something that that comes up. But just to be aware, there are civil and criminal penalties attached to the Brown Act. So the teleconferencing rules have changed in 2023 in response to the COVID pandemic. We are back in a period of time where there needs to be full compliance with the Brown Act. The standard during COVID of using Zoom meetings while the COVID emergency was declared is no longer in place. So as was demonstrated today, it is possible for members to appear via teleconferencing on good cause 2 times per year. There does not need to be a board vote on that good cause. It just needs to be stated along with any other persons over the age of 18 that are teleconferencing or that are in the same location as that member. The board still is able to allow the public to appear via Zoom to attend the meetings. That is not required by law, but many bodies are making that decision. And the old teleconferencing rules that have always been around continue to be in place, which is that if a majority of the board members are within the jurisdiction, it is possible for specific members to teleconference in so long as full posting requirements are met, which include listing the location of those additional places where board members are appearing and also allowing the public to appear at that location. So not a great option for folks appearing from their house, but somebody who is, for example, at a different city council chambers for an evening where other folks could come and make comments and observe, that would be okay under a fully properly noticed meeting.
I have a question just in regards to the, like what we read in the beginning of the meeting for Robin's situation, for example. Why does it matter if someone who is the age of 18 or older is present there, and why did we have to ask her about that?
So that's included in the text of the of that new exception to the general requirement that folks be in person, and that is so that if there, say for example, there was a room full of lobbyists in the room with a board member, that the public would be entitled to know that information. So it's just to make sure that in a location where the public doesn't have access, they have an understanding of what those circumstances are that a member of a board is appearing.
Oh, okay, thank you. It looks like Robin has a question. Hi, Robin.
So also, do I just need, in this kind of situation, do I just need to tell the staff ahead of time where I'm going to be, or was I supposed to say I'm at my home and give my address, which you don't Want to give out your personal address on a teleconference.
If you're using the exception that you availed yourself of today does not require you to state your location. There are general teleconferencing rules that are used in non-emergent circumstances where you would have to state the location and in fact make a posting at that location in advance in the same way you would if it was the standard location for the physical meeting. So when you apply Just Cause to appear from your home as you did this evening, you do not need to provide your address in that circumstance.
Thank you.
Any more questions on this topic before?
I have
Well, I
one
guess-
quick question about a quorum, I guess. So if we have like a 7-member council and we have 2 ad hocs that are 3 people each.
Mhm.
And then 2 people drop from our council, so the total number on the council goes from 7 to 5. Do we have to take people off the ad hocs to?
Yes, you absolutely should, because once you do not, any ad hoc has to be less than a quorum, and if the body is if the total number of the body drops such that the ad hocs are now going to be a quorum, you should remove members or pause them until you have a fully staffed board.
Thank you.
Any other questions from council members?
And Lizette, if I can just clarify, I am not going to be able to take legal questions from the public on the content of the presentation because I can't provide legal advice to the public. So, this is an informational item. So I just want to add that clarity before there's any public participation. I want to set expectations that I'm not going to be able to answer legal questions from the public.
Thank you. Good, thank you. We don't have any other questions from council members, so because it's 2 parts and it's a lot of information, I think we'll do 2 rounds of public comment. So right now we'll take public comment specifically on the Brown Act presentation that was just provided. So if anyone would like to comment in the room, we'll go with individuals present in the room first, and then we'll go on Zoom, and we'll start with Jim Duffy, and let me just get my, give me 1 second, let me put my.
Sure, I'm not gonna make arguments.
Okay,
I do have a question. I don't know if it qualifies as a legal question. So let's use the CAC. There's 7 members in the CAC. I'm a member of the public.
8 members.
If I wanna, okay, let's say there's 9, 9 members of the council. If I know that they're gonna be dealing with canines, and I go to talk to 5 of them individually about canines, and I'm not saying I'm coordinating them, but I talk to them individually. Are they violating the Brown Act because I'm trying to bring them all on board, or should they be saying to me, no, I can't talk to you, this is an active thing, and you might talk to a majority of our council, and I don't want to violate the Brown Act, because I have gotten that from 2 Rohnert Park City Council members who want to talk to me about anything that's on the agenda. Because God forbid I might talk to somebody else on the city council. Should they be doing that, or? That's my question. And sorry, it's spoiled for me.
yeah, thank you. Lizette, do we have anyone else? And we'll come back to ask if they can get, that question can get answered.
Hi there, my name's Alcina. Thanks for doing the hybrid meeting. I appreciate it. And thank you so much for this informational. I guess my comment is that I'm glad to see slide number 20. I don't know if you could put that up again, but it seems to me like we can ask questions and get better answers without really without having criminal penalties, because it's really frustrating to spend our time coming to physical meetings. And I've witnessed people ask what I think are extremely simple questions, and it's kind of shot down. No, we can't, it's the Brown Act. And I think that the whole point of the CAC is to be a body that's communicating with the public and educating the public and being liaison with the public for Iolero. So I would just like to encourage the CAC members to notice that it seems like we'd have to be pretty egregious to be have criminal penalties. So that's my comment. Thank you so much.
Thank you. How many more do we have? Was that? Okay.
Hi, this is Barbara Grisecki. I think I just got a thing to unmute, but I couldn't hear if I was, so I hope I'm okay. Is that
Yes. we
okay?
can hear you.
Okay, great. Well, thank you for doing this. I'm so sorry I couldn't be there in person today. My question, I know I'm not aware of the CAC ever violating the Brown Act, but I do know that the Board of Supervisors has done that several times. And I'm curious, like, what is the process for accountability and just kind of what is the scope of the repercussions? Those are my questions. Thanks.
Thank you. Any more public comment? Okay, so we'll close public comment for the Brown Act presentation and turn it back to you, Elizabeth. Do you mind addressing some of the questions that were brought up, please?
Through the chair, sure. I can't directly answer the question as to whether the conduct of any particular individuals in having or not having a conversation is appropriate. I can say that the reach of the Brown Act is to ensure as best as possible that members of a legislative body are not themselves making decisions as a group outside of the context of a properly noticed meeting. So to the extent members of boards want to make their own determination as to what the best way to ensure their compliance, that is their decision. But the reach of the Brown Act is to the members of the board itself. And, I point back to the concept that, using an intermediary to reach consensus is inappropriate under the Brown Act. But the focus of the Brown Act is on what the board is doing and not the public. Regarding accountability, I would just point you to slides 19 and 20 of the presentation that talk about the legal ramifications of violations of the Brown Act. And I think those are the only questions that I heard that I could give answers to.
Okay, thank you. So we'll move on to the next presentation.
So give me just a moment. I need to stop sharing screen on this one to pull up the other.
I don't think that was.
Apologize, I am not highly skilled in the use of PowerPoint. Can you see the front slide for this?
Yes.
Great. Okay, so part 2, the Public Records Act, and I apologize for the denseness and the extent of this presentation. These are two totally separate concepts that are two entirely different trainings. So, ooh, that was fancy. Okay, so the California Public Records Act governs the public's access to government records, and it is set forth in the Government Code starting at section 7920. The access to public records is a constitutional right in the state of California. The policy of the Public Records Act is to ensure that, mindful of the right of individuals' privacy, that to declare that the access to information concerning the conduct of people's business is a fundamental and necessary right of every person in the state. And so the basic rule that always applies is that a local agency record must be disclosed to the public upon request unless there's a specific exemption. So the default position is always, if something is a local agency record, it should be produced. Let's talk a little bit about the scope. What are considered public records? A public record is any writing containing information related to the conduct of the public's business that is prepared, owned, used, or retained by a state or local agency, regardless of physical form or characteristic. So the first part of that, well, what is a writing? And this has expanded a lot over the last 20 years or so. So the way the code defines is that a writing is any handwriting, typewriting, printing, photostating, which I'm not even sure what that is, photography, photocopying, transmitting by electronic mail or facsimile, or any other means of recording upon any tangible thing, any form of communication or representation. This was written before people were using text messages for government purposes. So consider that also to be included in a writing. So writings include handwritten notes, computer printouts, photos, CDs, flash drives, anything in the cloud that's can be considered a record, audio and video recordings, including meetings of Zoom and team meetings, also emails, text messages, and the chat function on Zoom and Teams. So if you're having a side conversation during a meeting and you're having it in writing in the chat feature, that is a public record. That is considered a writing. So it doesn't just have to be a writing, it also has to be containing information about the people's business. So to determine if a writing relates to the business, you want to look at the content of the record, the purpose for which it was written, the audience, and whether it was prepared by an employee or other volunteer person that's purporting to act within the scope of their authority working with that public agency. So it has to be prepared, owned, used, or retained by the public entity. It doesn't have to just be in the physical possession of a public agency for this to count. So certainly if the county has within its email servers a copy of an email that emails are considered written records, if it's about the public's business and it's in an email server that's run by the county, that is within the regular possession. Constructive possession is when there is a public record that is not physically within the control of the county or the entity, but that entity has the right to control, either directly or through another person. And the case that's included in this slide, and I'm going to talk about the city of San Jose versus Superior Court, was about text messages on a private cell phone. So in the city of San Jose case, the plaintiff sued the city for failure to turn over documents that were on a personal device that otherwise met the definition of a public record. So the city had argued that because it was on a personal device, it wasn't a public record, but the court disagreed and held that constructive possession means the right to control the record, and a writing that was retained by a public employee conducting agency business has been retained by the agency within the meaning of the law, even if it's on a private device. So what that's going to mean to individuals, I'll leave the slide up for a second, for this particular council, if you are sending email about the content of your role on the council, so it's written and it is a public record in the sense that the content covers you're doing it in the capacity as a member of the council, those are considered public records, even if you are storing them offsite on a private device. I won't get into too much detail on how requests are made since staff will be handling most of these requests, but there's no specific format that is required by law. Some entities do have a form, but the public is not required to follow a specific format in order to be able to have their request responded to. It does need to be specific enough that the records are identifiable and that staff can locate the records, but they don't need to identify exact records. So a request for all of the emails between council members that deal with the concept of dogs, right? That would be sufficiently articulated to count as a sufficient request that would have to be responded to. The general deadline is that within 10 days, staff responds to a Public Records Act request. They don't necessarily need to provide records within that 10 days, but they do need to make their initial response and include information about whether there are responsive documents, and then give an estimate by when the non-exempt documents will be available. Local agencies can generally avail themselves of a 14-day extension by right. So as long as you state that there's a reason for it, that they're voluminous records or need to coordinate multiple departments, they can request an extension without needing the approval of the requester. So that's kind of the structure of how the records get turned over. So the other big concept, other than what is considered a record, is what is exempt from the Public Records Act. And in general, when the county is responding to a PRA request, county staff will pull together the responsive documents. So if there's a request that asks for something that the members of the council will have, staff will reach out to you and ask you for copies. And then generally my office will go through responsive records to see if there's anything that should be withheld and not turned over. So the default position is if it's on point, it goes, but if there are specific exemptions, we will help comb through and apply those and talk those through with staff before records are produced. So the exemptions need to be either expressly set forth in the Public Records Act itself or imported from other provisions of state and local law. So they all need to be express. One of the big ones is the public interest balancing test. If it can be demonstrated that the interest served by not disclosing a record clearly outweighs the public interest, that is one circumstance in which records can be maintained in confidence, but the burden of proof in making that sort of a claim is on the public entity. So if there's a really good reason it would be damaging either to the public or to the county's ability to perform a certain function, if this particular piece of information were to be shared, it can sometimes be held back, but there has to be a strong justification. So there are specific exemptions from disclosure that are set out in the statutes. Exemptions aren't absolute. There are exceptions to them, and they're fact driven, which is why council is generally involved. So drafts are exempt if there are preliminary drafts, notes, or memoranda that are not retained in the ordinary course of business, if the interest in withholding clearly outweighs the interest in disclosure. So if a public entity always holds on to all of the old copies of contracts that were in the middle of discussion, just as a matter of policy keeps the drafts, those will not be exempt. If there's a bunch of back and forth on something on a draft that's not quite final yet, someone asks for copies of something that is, for which that would be responsive, but you just haven't gotten rid of the drafts because there's no final yet, those would potentially be exempt. Those are the kinds of things that public agencies are intended to be allowed to hold back because it's not showing the final work product. There's an exemption for pending litigation. So records that are prepared in connection with litigation are considered exempt until litigation is over. Investigatory records are exempt. So this applies to law enforcement, licensing, or correctional investigatory matters. And of course, there are much broader legal protections for certain things related to the content of this particular council. I'm sure you're all aware of the sensitivity of personnel records, but in the broader sense, investigatory records are also protected, even if they aren't under the more narrow protections that apply to most of the records that ILARO deals with. So there are also exemptions for privileged information. So anything that is made privileged by state or federal law or the provisions of the evidence code. For the most part, for those we're talking about attorney-client privilege. So if you are sending or receiving a communication for the purpose of getting legal advice, those are privileged. Just copying me on an email does not automatically render it privileged. It has to actually be in furtherance of getting legal advice for that communication to be privileged. Official information is also privileged. So official information is a term of art that applies here under the evidence code. Information that is acquired in confidence by a public employee in the course of their duty and not open or officially disclosed to the public prior to the time of the claim the privilege is made. So if disclosure is prohibited by state or federal statute, it is an absolute privilege. In others, it is conditional, where you're looking at the balancing. And so one example of official information, the county will take in certain information in connection with administering aid grants to needy families within the county. And there are certain information like social security numbers and income information that come in the process of that. That's considered official information. It's being taken in confidentially by the county in order to discharge its duties and isn't being shared publicly. So those kinds of information are protected from disclosure as well. Deliberative process is one of the big ones that would likely apply to communications within this particular body. So communications that in the application of the balancing test, the value in withholding is greater than the value of disclosing, is, you know, that's a requirement. But documents that are displaying the public official's thought processes can be protected. So if two members of the council are going back and forth on a concept related to, you know, how they feel about a draft report that's about to go out and what sort of changes might be suggested in a policy, those are the kinds of discussions that are intended to be protected by the deliberative process. The kinds of things that if the public was, or that if the public agency was required to disclose, would have a chilling effect on the ability of the public officials to really get into their work and make thoughtful determinations. There are exemptions for propriety information, so trade secrets, copyrights will also protect information from disclosure. There are a whole laundry list of other express exemptions that this body will likely not have to deal with, although I will point to the fact that personnel records are, as a general matter, exempt from disclosure with certain statutory exceptions. There is a catch-all exemption that's called the balancing test. So when a local agency can demonstrate that on the facts of a particular case, the public's interest is served by non-disclosure in a way that clearly outweighs the interest in disclosure, specific pieces of information can be withheld. It's a high standard, and it should always be discussed with counsel before, you know, folks should not, when turning over records to staff for disclosure, shouldn't themselves be saying, oh, well, this particular thing is so, you know, so important, it has to be withheld. Share it with staff, have that conversation with counsel, and then we'll determine what needs to happen from there. So this slide just lists some additional resources. There's a really good summary of the Public Records Act that the California League of Cities puts together, and there's a link to that document in this slide. I have downloaded and referred to it with some regularity, and you can find that at this location. And the Attorney General also has a good summary of the Public Records Act as well at the first link there. Sorry, I'm talking so fast. I'm trying to get you home before midnight. Are there any questions from the council?
Can you give an example of something where the catch-all exemption would be applied? Because I'm thinking of, like, you know, in like shows when the government kind of does something that they're not supposed to, but the public is benefiting from whatever the government did, like government secrets. So it's better to not let the public know instead of letting them know, because disclosing, non-disclosing outweighs disclosing. Is that what you're saying?
Yeah, I mean,
and that was an extreme example, but
right, you're not going to be able to make that showing because, you know, if the government is doing something, you know, nefarious or sneaky, the fact that there are sort of downstream benefits to the public is not going to be the kind of thing that will survive the balancing test. It is more intended for situations where I'm having a hard time coming up with a good example. You know, say for example, there were, you know, potentially going to be changes in the scope of how the advisory council was going to be, it was going to be handled, and there were, you know, internal conversations about what might do, you know, what might be the best way to improve the public's access to the underlying information, right? Where you're really getting into the weeds of the decision-making process. there could be a circumstance where sharing that information, even though there's nothing that's technically privileged about it, would harm the ability of the council to do its work to such an extent that it makes more sense to withhold it. So it's not where a public agency has done something bad, but it has good downstream impacts, and so they can protect themselves. That would be a situation in which you would not be able to make the balancing test showing. It really has to be that on the substance of that document itself, it would be, usually it's something like a chilling effect. So if, so one example that comes up a lot is in the context of the purchasing agent for the county goes through evaluations of proposals when trying to get into contract with particular entities. And usually there will be a group of folks who sit down and go through all the proposals, and they talk them out and they write their notes and they score the proposals. And then they figure out which is the best one, and then they offer the contract. So when we get Public Records Act requests asking for the names and specific notes of each of the folks that were involved in that process, we generally use the balancing test to hold those back, to say that if folks' individual impressions of individual contractors was made public, it would be impossible to get anyone to serve on these committees, because they know they can't freely engage with the content of the proposals in order to evaluate them properly. So it's not that anyone's doing anything wrong, but there could be a chilling effect on the agency's ability to get good information if folks knew that they couldn't rely on those conversations being confidential. So that's the kind of situation in which the balancing test would likely be applied.
Okay, thank you. Any other questions? Okay, seeing none, then we'll do another round of public comment. So we'll open up public comment for individuals in the room first. Does anyone have any public comment? Seeing none, is there anyone on Zoom with the hand raised? Okay, we'll go ahead and close out public comment and bring it back to the council for any last comments or points that you'd like.
I just thank you for your time and attention. And if there are any specific questions for which you need legal advice, my name is on the slide and my email follows the standard county convention. So you can reach out to me at any time.
Thank you for your time.
Thank you, Elizabeth.
Thank you.
All right, I will stop sharing.
Okay. All right, so we'll move on to item 9, CAC committee reports. We'll start with community engagement.
The community engagement. 2 of the 3 members of the community engagement met this evening before this meeting, and it's just because it's a standing committee, it's open to the public, and so we had a public meeting talking about strategies and targeting what audiences we want to target, and I come up with sort of a list of things that we'd like to do. I would like to encourage other members of the CAC to participate in the committee, both because it would make it easier if we had additional people to share the work. But whether or not you serve on the committee, I'm asking everyone to, part of our charge in Measure P is that we are supposed to engage in community engagement. And so I would like to ask everyone to commit, not publicly, but you can commit privately, to doing at least one community engagement activity a year. I don't think that's too much to ask of people, and it's a big part of our work. And we should be doing a better job of it. So we'll be coming back. We're going to meet again in 2 months, and we'll be coming back with some specific ideas. I will tell you that in the meantime, I personally, after having contacted, and I'm sorry, Sean, I meant to CC you, and I didn't. I contacted Sheriff Engrum and told him that I wanted to do some leafleting away from the jail, but outside the jail during visiting hours. And I asked him whether he wanted me to contact anybody in the jail for that. And he said no, that as long as I was going to be out at Ventura and Cullen Drive, that there was no need to do that. So you'll probably, if you're around there, people will be seeing us periodically outside, visiting hours, just handing out ILR brochures. So we're gonna do that, and we have some other ideas, but they'll come back to you in a more organized fashion. Oh, I don't know that I can mention that as part of, is that
Okay,
part of,
that's very good.
but that I think is not ours, right? That's, oh, well, no, I can answer that, that's it. One of the events that Lizette is probably going to be going to this year, and she and John and I and you went to last year? Is memorial for the anniversary of Andy Lopez's death. There's going to be an event at the Andy Lopez Community Park on October 22nd from 4 to 6:30. And I just mentioned that as part of that. So that's my report.
Okay, thank you. Race and Identity Profiling Act.
So the ribbon ad hoc met twice in the month of September on the 13th and the 21st. We are continuing to plow through and analyze the second half of 2021 with the data provided to us. I think making some tremendous traction. Our current mission is to submit another set of questions to the sheriff's office. So we are endeavoring on that. And that goal is to give over us another set of questions. But again, I personally, I think that us diving into the data it's doing.
You guys want to add anything? Okay, so we'll be reaching out to you soon, Sean, to see if we can schedule a meeting. Okay, recruitment and hiring practices ad hoc.
What do you want to report?
Exactly.
Do you want to report?
Sure, I'm happy to report that. So we actually met with, through Zoom with Chief Cregan of Denver PD. And, it was myself, Nancy, Jalissa, Nathan, and John was also, was there anyone else?
That was it.
Yeah. So we've got to ask them more questions. It's full, 7 PD is fully staffed at this time. And it's not, apparently that's, that's been a challenge for a lot of agencies. And so we asked many questions on, what his approaches were to getting the word out that he was hiring, how he reduced barriers to the hiring process, or eliminated or minimize barriers to the hiring process. And am I missing anything?
No, just that we are going to be asking,
Yes.
I've written Sean asking to have a meeting with somebody from the sheriff's department, and we're going to be coming up with our list of questions shortly for you. Although they will not be a sort of a final list, but they'll be a, start the ball rolling. Thank you.
Anything else? Okay. Policy recommendations review ad hoc.
So our brand new ad hoc, myself and Tom Rose and Alan, Prayville, member of the community, met last week. We have been at work on researching, so let me step back a second. This ad hoc is policy recommendations review is what it's called. And I will say the policy recommendations of the CAC that are published on the website include extremism, homelessness, conflict of interest, body-worn camera, immigration, canine firearms, mass demonstrations, restraint, use of force, and de-escalation. That might be a big mouthful. for one small ad hoc. So I think part of what we are going to do, and we are researching and focusing on use of force issues. We've engaged with Sean and his office, trying to obtain some relevant data to our analysis and understanding of where we are, I think really for the purpose of informing what we would ultimately request as a meeting to have an exchange of ideas about where we are. I would say our focus right now is in the area of canine policy and force policy. As we meet and sort of pursue our work, we may well come back to this body and say, this ad hoc needs some narrowing because of the breadth of what I just identified. But I feel like that given that this is a month old, I feel like we've made a pretty good start. We've had a very fruitful meeting. We've been doing research. We've been engaging with the sheriff's department in order to inform some meetings that will include revisiting the CAC's previous policy recommendations and our own take. Which we would of course bring back to this body as we develop it. So that's kind of my summary.
Okay. Yeah, go ahead.
Well, I just wanted to say, you can take extremism off your list because you actually have a written response from the sheriff.
Perfect. Okay, that was it. Okay, so now we move on to item 10, open time for public comment. This section is intended for items not appearing on the agenda, but within the subject matter jurisdiction of the CAC. Please state your name and who you represent. If applicable, comments will be limited to 3 minutes. And do we have any hands raised from our 5 attendees? And we do have Jim in the room. Okay.
Just a quick announcement, next Tuesday night, 10 at 6 p.m. The Clean Committee is going to be hosting a webinar on racial identity and profiling act 8953. We're gonna have a couple members of the RIPA board are do an hour presentation, we'll take questions. Lorena is going to be our moderator for the events. It's a chance for folks to learn a little bit more about RIPA and how to look at the data that we get from our law enforcement agencies and what we can do with that. Online, it's not online right now.
Thank you, Jim.
Registration through Clean's website or Facebook.
Okay, yeah, cleancommittee.org. You can register there. What's that?
Yeah.
Are we able to send out that information after the meeting? Yeah. Okay, perfect, thank you. Sorry, I haven't checked the emails. Okay, so with that, we'll close public comment and move on to item 11, request for future agenda items. Are there any requests from any CAC members? Okay.
I'd like to, we had put on the last agenda for future agenda was the ad hoc on evictions. And I'd like to just post that again. For future, I don't want us to forget about that.
We had needed to be running rolling list of potential future.
Okay, CAC announcements. Does anyone have any announcements to make related to CAC business? Okay, seeing none, we will move to item 13, adjournment. The next CAC meeting is on November 1st at 6 p.m. in this, in this room here at the Finley Community Center. Thank you everyone for joining us tonight and we'll see you next month.
Thank you.
Very good.
Thank you. Thank you. Nice job.
Okay.
It's great.
Was that?
Yeah, I
I don't think you're the host anymore.
You're not the host.
Oh, yeah. It was still recording. But normally it says end webinar. If you just send it. Yeah, but